Hello everyone, hope all of you are doing good and have been continuous with respect to writing the questions. So today we are on day 22. Let's start with the topic of the day, parliamentary procedures, and we will be talking about the doctrine of basic structure. So let's see what are the constituents that have to be studied. Now, so when we talk about the parliamentary system and the amendment procedures, so in this regard, first we need to understand what is the nature of the parliamentary system, what have been the constitutional debates about the adoption of the parliamentary system, why India has adopted this particular parliamentary system, okay, how, there has been a rich experience of living with the parliamentary system. Then we will be talking about the features of the parliamentary system. We also compare it with the presidential system. Okay, what are the features of the presidential system? How parliamentary system differs from the presidential system. Then there are debates whether India should move from the parliamentary system to the presidential form. Okay, so we will be talking about those debates. Then with respect to what is the procedure of amendment, how it is also, there is how it restores the basic framework of the constitution and also how it is adaptive to the socio-economic changes in the country. Okay, so this is all that we will be studying with respect to the parliamentary procedures and types of amendment. All right, then the doctrine of basic structure. So what is the doctrine of basic structure? What has been the origin? Was it there before it has been explicitly spoken of in the Keshwananda Bharati case? So what the evolution has been, okay? Then what have been its effects? Also, what are the debates that scholars are making on the advantages and disadvantages of this doctrine of basic structure? So means arguments for and arguments against the doctrine of basic structure, okay? Then what are the elements of the doctrine of basic structure and what is its relevance today? Okay, so we study all these things with respect to the doctrine of basic structure. So day 22, now let's see the question. How does the amending power, how does the amending procedure in the Indian Constitution reconcile the dynamic nature of the Indian Constitution, okay, and the basic framework of the federal polity? So here we will be talking about so question is saying how does it reconcile? What does it reconcile? Okay, the amendment procedure within the Constitution. Okay, how it reconciles what two things? One is the basic framework of the federal polity that India is, okay. On the other hand, how it is adaptive to the dynamic changes. Now, if this question had been asked in the GS, okay, so you would have spoken about how the different types of way amendment is done within the scope of Article 368. What is it outside the Article 368? How it is done by the simple majority of the parliament? What are the issues which have been addressed that way? Okay, and then we will be also talking about the view of the judiciary in various cases, how this amendment procedure has been able to reconcile this basic framework as well as the dynamic changes in the Indian society. But when we are writing the same question in political science, we have to explain the philosophy of any concept, okay? So the amendment procedure also has a philosophy. So where did we see this? So the whole idea comes in the debates of the Constituent Assembly, okay? So we see that how the issue of amendment has been a matter of debate, controversies, right, within the Constituent Assembly. And different scholars talk about this philosophy also. So in this sense, the philosophy of amendment. So we have the view of Granville Austin. We will be talking about the view of K.C. Weir. So we talk about the philosophy of amendment, how? So the views of scholars. So you talk about Casey Weir's view, Granville Austin's view. Now you will have to remember all this, okay? Otherwise your answer will be again another GS answer extension. If you have to make it Pol Science, that different enrichment has to be there. Then within the Constituent Assembly, what key members of the Constituent Assembly have spoken of it. So you can talk about the view of B.N. Rao and how he had suggested the twofold method for amendment, okay? But then we say that what method the Constitution adopted, okay? So we spoke of a threefold approach. Two within the scope of the Article 368 and also outside it by the simple majority of the Parliament, okay? And in 368 it is special majority of the Parliament, right? As well as the special majority plus the consent of the states, right? Of the consent of the states has been there. So these two method and three approaches we will be talking of. Then we will be talking of what has been the view of judiciary with respect to this. So you talk of the various cases to explain how the amendment procedure has been able to meet this reconciliation from the beginning until we will be talking of the Keshwananda Bharati case, okay? And then we derive at a synthesis of how it is being done, okay? So this is how your PSIR answer will be different from your GS answer, okay? Now let's see this enrichment, how it has to be done. So firstly we are saying the issue of the amending procedures of the Constitution happened to be one of the most debated, just cancel, it is wrong, it is not least, most debated and controversial issues dealt with by the Constituent Assembly. What does Casey Weir say? That this Constitution strikes a balance by protecting the rights of the states while leaving the rest of the Constitution to be amended easily. He has admired the variety of amendment procedures contained in the Constitution of India. What did he say? The variety in the amending process is wise, okay, but rarely found. So this commentary will enhance your answer. Then the view of Granville Austin. What does he say? The amending process has proved itself, okay, one of the most ably conceived aspects of the Constitution. Although it appears complicated, it is merely what? Diverse in nature. Then we talk about that yes, the Indian Constitution is what? Neither flexible nor rigid, but a synthesis of both, okay? And we have the midway approach from what? From the US as well as the UK. So how we have adopted a middle path between these two extremes. Then B.N. Rao in the Constituent Assembly had spoken of a twofold procedure for amending the Constitution. So the twofold approach that has been pointed out by B.N. Rao. So he had said that amendment should be passed by 2/3 majority in both houses and ratified by a simple majority of the provincial legislatures. And the transitional provisions may be amended by simple majority in the Parliament. So then we had adopted the threefold methods of amending the Constitution, okay? So 22 other articles apart from 368 can be done by what? By the simple majority. So first, outside the scope of Article 368 is simple majority of Parliament, and even though there are multiple ways, okay, articles, you will not have to write all the provisions that which can be amended by simple majority. Just mention 2-3. I have mentioned this all for you so that you know and it is easier to revise as a model answer, but only 2 to 3 provisions which can be done largely of key significance you write. What can be done by simple majority, how it is outside the scope of the Article 368, right? Then we talk about by the special majority of the Parliament, okay? So here what is it? Majority of total membership of each house and a majority of what? 2/3 of the members being present and voting. Now, so here then we talk about all the provisions, fundamental rights, DPSP, other provisions which are not covered by the first and the third categories. Then the special majority of parliament and consent of states. Here more issues are which are related to the concern of the federal polity. Okay. So with respect to the president's election, okay, Supreme Court, High Court, key concerns, GST Council, all these matters are what? These are matters which are also requiring the consent of the state. So this has to be elaborated, which means even if we are writing the scholarly aspect, the basic framework of the articles, the provisions is something you will have to know verbatim. You will have to be clear about the procedures, the provisions of the constitution, okay? So in this sense, then revising polity becomes very key. You cannot write a very good IGP answer associated with constitutional frameworks without knowing the provisions very well. तो वो भी याद रखना है, ठीक है? अब, then we talk about two schools of thought of what they are saying about this Article 368, okay? So the legal positivism say what? That whatever provisions have been mentioned in the constitution, all right? So parliament has to be abiding by that. That the parliament must confine itself to what has been provided in this regard without making any attempt to do what? To derive implied powers of attainment. So what has been done and what has been within the scope of Article 368, it should be abiding by that. The other school of thought says, which is not legal positivism, talks about that no, it has to interpret beyond this also. Why? Because there are continuous changes that are happening in society. So we might have to widen the ambit of our interpretation. So in the context of socio-economic changes, second school of thought, amendment should be viewed by the judiciary, obviously, okay? In the context of the requirements of the socio-economic needs instead of strict legal provisions provided for in this regard, okay? Now, so then we talk about what has been the view of judiciary pertaining to the procedure of amendment, and you give some examples also, for example, on the fundamental rights, DPSP, okay? Expansive role that judiciary also acquired pertaining to the amendment procedure. So first you talk about Shankari Prasad case, then we talk about activism that has been there with interpretation in the Golaknath case, okay? Then how the parliament brought 24th and 25th amendments, what came in the doctrine of basic structure came in the Keshwananda Bharti case, okay? So in the contemporary times, we conclude that the issue regarding amendment procedure and ancillary provisions appear to be settled in favor of a strong position of the Supreme Court, okay? And has progressively attained the position of commanding heights in the constitutional framework of governance in the country. Because Supreme Court has acquired that authority, right? Now, so the doctrine of basic structure is also the reference point for both. For whom? For the parliament as well as the judiciary. They should try to work the constitution insofar as amendments are concerned rather than subverting it. So understood how the philosophy, you have to show that debate, you have to show the school of thought which say no, the amendment has to be perceived only within how much has been given in the constitution. And other school of thought says no, we have to adapt it as per the socio-economic needs of the country. Is it clear? Now, let's move to the next question, okay? In modern India, judiciary has expanded the frontiers of its envisaged role. Trace the evolution of the changing role of judiciary with relevant cases. Examine with relevant examples the pros and cons of an active and powerful judiciary. Okay? Now understand, the question is reading, I'll just read it again for you. Question is talking about modern India, parliamentary form of government, right? We have adopted. So context will be obviously that. Now, in modern India, judiciary has expanded. So on one hand, we are a parliamentary democracy. On the other hand, it is saying judiciary has expanded its role. Judiciary has expanded its role, okay? We have to talk about the evolution of this expansion, how it happened. After explaining this evolution, what is the next idea? You have to talk about what is the pros and cons of this particular expansion. So have you deconstructed the components that have to be there in the question? Okay. So firstly, when we talk about modern India, we will say that we have what? We don't have the strict separation of powers. There is a fusion of power because it is the legislature as well as executive which are, doing the idea of making laws within the country. And in this system, judiciary has the role of what? Interpretation of the constitution, adjudication of cases pertaining to the various disputes that are arising out of the implementation of the constitutional provisions. Okay? Then we will be talking about how this expansion is happening. So let's go through the introduction, which will be different than the GS. So modern nation states functions through a set of institutions. A parliamentary democracy works on the principle of fusion of power. Okay? But in the making of law, there is direct participation of the legislature as well as the executive. And judiciary is the arbiter in interpreting the constitution. Okay? And guardian. Okay? And conscience keeper of what? So conscience keeper of the normative values that are authoritatively allocated by the state. So we have spoken of role because they are saying judiciary has expanded the role. So what is the original role that has to be explained? What is the envisaged role? So we are saying this is the envisaged role within the system we are having today. सबको ये काम करना है. अब इस काम को कैसे इन्होंने expand किया, function को कैसे expand किया. So we move on to that. Now we say in the past few decades, court has opened the door to a public spirited citizen, expanded frontiers of FR and even rewritten parts of the constitution. It has transformed itself into an arena in which political, social, economic debates are fought and socio-economic justice is delivered. Okay? So here we will be talking of the expansion. Now we will be talking of how this expansion evolution happened. So understood? You have to first toe the line of the question. Question is saying, in modern India, judiciary has expanded its envisaged role. तो envisaged role तो बताओ पहले था क्या, काम क्या करना था और कैसे expand किया उसको. ठीक है? This shows clarity. So now let's see the evolution. Court in its early years restricted within the confines of the judicial space and the power of judicial review was judicially used. Okay? In A.K. Gopalan versus State of Madras, it took a narrow interpretation and confined the scope of fundamental rights as what? Procedure established by law. Shankari Prasad, it held that the power of the amendment of the parliament, it is belonging to the parliament and it is unlimited power of amendment. So these two cases reflect that narrow interpretation of the working of the judiciary. Then let's see the expanded version. Okay? In Golaknath case, it acquired an active role. It acquired an active role and held amending power of the parliament was limited. Okay? It is subject to fundamental rights enshrined in the constitution. Replaced popular sovereignty to constitutional sovereignty and gave itself the power on the validity of constitutional amendments. Then it became more active by rewriting parts of the constitution. In which way? Okay? So the implicit part has been made explicit by the doctrine of basic structure in the Keshwananda Bharati case. So we have shown the evolution. Fine? Now, in the spirit of the envisaged or envisioned dream of constitutional framers, Since 1980s, there has been a gradual expansion of fundamental rights. Example through PIL, okay, introduced by Krishna Iyer and Justice P.N. Bhagwati. And it took this from the classes to the masses, the expansion of the scope of fundamental rights. And the poorest sections of society are knocking the doors of the judiciary for their rights. Then we will be talking of the impact of this expansive role in terms of facts. So still how justice delivery has remained a key challenge. How there is pendency of cases. How there is delays also. So we talk of this problem by explaining certain facts. Then we give the scholarly view on these facts. So imagine an answer is such a good mix of the broad idea, the philosophy, okay, of what is the envisaged role of the judiciary. Then we talk about how we can see this expanded role, how this role evolved. We have to explain the evolution. Then we come about what is the arguments for and against. तो एक तो facts के through explain कर दिया what are the issues with this expanded role. अब scholars क्या बोल रहे हैं इस expanded role के बारे में? What are the cons of it? What are the pros of it? So IGP answer is that beautiful mix that you'll have to evolve. Okay? So let's come. So Upendra Bakshi says it is a chemotherapy on the carcinogen of the Indian body politic because representative institutions have not been able to fulfill the desired role, and that's why it is judiciary who has done a chemotherapy on this cancerous problem. Okay? Right? Lavanya Rajmani, Aragya Sen Gupta, Pratap Bhanu Mehta. Okay? They criticize this role. Even Mathur and Katju say that they should be confining and exercising restraint. So arguments for both have also been given. Then what does Ronald Dworkin say? So how he synthesized? So he says there are two things. One is policy. Ronald Dworkin say one is a matter of policy and one is a matter of principle. Okay? So each branch of government is best confined to its envisaged role. Right? So who should be doing policy making arena and who should be applying the principles? Alright, so principle is legitimate domain of the judges and policy making of the legislature and its agents. So he is synthesizing in this way by explaining the policy and the principle. So today most contested conclusion, most contested issues are brought to what? Brought to and resolved by the court. The court possesses not just immense decision making power but also wields considerable powers of implementation. Thus, it has played a critical role in shaping India's constitutional democracy. It has delivered numerous progressive decisions, yet if it becomes too much powerful, what will it lead to? The problem of imperium in imperio, right? Which drafters of the constitution had wished to avoid. However, the only check possible in the exercise of power is what? Self-imposed restraint by the judiciary. So, what all we derived in this particular question? Okay, let's see. So, we spoke of, okay, envisaged role, what is philosophically, what has been the envisaged role, okay. Then we talk about expanded role, evolutionary role, then give facts, give views of scholars to explain this problem, and then synthesize. So very beautiful mix of cases, facts, scholars' view, conceptual clarity has to be there. That's when an IGP answer gains enrichment, different from GS answers. सब tools को use करना आना चाहिए, ठीक है? So yes, this is about today. We'll meet tomorrow again. All the best. Thank you so much.